This case is directly parallel to the Prince case in our view. In that case, the court struck down several provisions of the Brady Act, but went on to say it had no business addressing the severability of other provisions that did not apply to the people before the
What he's thinking of is this. I think Justice Scalia is thinking, I suspect, of imagine a tax which says this tax is amount Y goes to purpose X, which will pay for half of purpose X. The other half will come from the exchanges somehow. That second half is unconstitutional. Purpose X can't possibly be carried out now with only half the money. Does the government just sit there collecting half the money forever because nobody can ever challenge it? You see, if it were inextricably connected, is it enough to say, well, we won't consider that because maybe somebody else could bring that case and then there is no one else?
Yes, we think that is the proper way to proceed.
Mr. Needler, it's not a choice between someone else bringing the case and a law staying in place. And what we're really talking about, as Justice Sotomayor started this discussion, is who is the proper party to take out what isn't infected by the court's holding. With all these provisions where there may be no standing, one institution clearly does have standing, and that's Congress. And if Congress doesn't want the provisions that are not infected to stand, Congress can take care of it. It's a question of which side should the court say, we're going to wreck the whole thing, or should the court leave it to Congress?
We think the court should leave it to Congress for two reasons. One is the point I'm making now about justiciability or whether the court can properly consider it at all. And the second is we think only a few provisions are inseverable from the minimum coverage provision. I just would like to...
Judge, before you go, Mr. Kneedler, I'd like your answer to Justice Breyer's question. I think you were interrupted before.
Yes, we believe that in that case the tax provision should not be struck down. In the first place, the Anti-Injunction Act would bar a direct suit to challenge it. It would be very strange to allow a tax to be struck down on the basis of a severability analysis. Severability arises in a case only where it's necessary to consider what relief a party before the court should get.
Suppose there was a non-severability provision in this Act. If one provision were to be held unconstitutional, then someone would have to bring a separate lawsuit challenging every single other provision in the Act and say, well, one fell and the Congress said it's a package, it can't be separated. That's your position?
The fact that such a clause might make it easy doesn't change the point. Article 3 jurisdictional problems apply to easy questions as well as hard questions. If I could just...
But there's no Article 3 jurisdictional problem, and Justice Alito's hypothetical that this is a remedial exercise of the court's power to explain the consequences of its judgment in this case.
But this court has said that one has to have standing for every degree of relief that is sought. That was in Davis. That was Los Angeles versus Lyons.
Mr. Kneedler, don't you think it's unrealistic to say leave it to Congress, as though you're sending it back to Congress for Congress to consider it dispassionately, on balance, should we have this provision or should we not have provision? That's not what it's going to be. It's going to be these provisions are in effect. Even though a lot of you never wanted them to be in effect and you only voted for them because you wanted to get the heart of the Act, which has now been cut out. But nonetheless, these provisions are the law, and you have to get the votes to overturn them. That's an enormously different question from whether you get the votes initially to put them into the law. There is no way that this Court's decision is not going to distort the congressional process. Whether we strike it all down or leave some of it in place, the congressional process will never be the same. One way or another, Congress is going to have to reconsider this, and why isn't it better to have them reconsider it what should I say, in toto, rather than having some things already in the law which you have to eliminate before you can move on to consider everything on balance?
We think as a matter of judicial restraint, limits on equitable remedial power limit this court to addressing the provision that has been challenged as unconstitutional and anything else that the plaintiff seeks as relief.
But
Here,
when
the
you
only
say judicial restraint, when you say judicial restraint, you are echoing the earlier premise that it increases the judicial power if the judiciary strikes down other provisions of the Act. I suggested to you it might be quite the opposite. We would be exercising the judicial power if one act was, one provision was stricken and the other remained, to impose a risk on insurance companies that Congress had never intended. By reason of this court, we would have a new regime that the Congress did not provide for, did not consider. That, it seems to me, can be argued at least to be a more extreme exercise of judicial power than striking the whole.
I think not.
I just don't accept the premise.
I think not, Justice Kennedy, and then I'll move on. But this is exactly the situation in Prince. The Court identified the severability questions that were briefed before the Court as important ones, but said that they affect people who are rights and obligations of people who are not before the Court.
Mr. Kneedler, move away from the issue of whether it's a standing question or not. Make the assumption that this is an issue of the Court's exercise of discretion. Because the last two questions had to do with what's wise for the Court to do, not whether it has power to do it.
Right.
So let's move beyond the power issue, which is your answers have centered on, and give me the sort of policy. And I know that's a bugaboo word sometimes, but what should guide the Court's discretion?
Well, we think that matters of justiciability do blend into, as I understand, blend into discretion, and in turn blend into the merits of the severability question. And as to that, just to answer a question that several justices have asked, we think that severability is a matter of statutory interpretation. It should be resolved by looking at the structure and the text of the Act, and the Court may look at legislative history to figure out what the text and structure mean with respect to severability. We don't
Either what happened to the Eighth Amendment? You really want us to go through these 2,700 pages? And do you really expect a court to do that? Or do you expect us to give this function to our law clerks? Is this not totally unrealistic that we're going to go through this enormous bill, item by item, and decide each one?
Well,
you don't have to. Because
well, that is
Congress said was essential. Correct?
That is correct, and I'd also like to I just wanted to finish the thought I had about this being a matter of statutory interpretation. The Court's task we submit is not to look at the legislative process to see whether the bill would have passed or not based on the political situation at the time, which would basically convert the Court into a function such as a whip count.
And
that's
Mr.
not
Needham,
the Court's.
that would be a revolution in our severability law, wouldn't it?
It would.
I mean, we have never suggested that we're going to say, look, this legislation was a brokered compromise, and we're going to try to figure out exactly what would have happened in the complex parliamentary shenanigans that go on across the street and figure out whether they would have made a difference. Instead, we look at the text that's actually given us. For some people, we look only at the text. Should be easy for Justice Scalia's clerks.
I think that's.
I don't care whether it's easy for my clerks. I care whether it's easy for me.
I think that's exactly right. As I said, it is a question of statutory interpretation.
Well, how is that? What's exactly right? It's a question of statutory interpretation. That means you have to go through every line of the statute. I haven't heard your answer to Justice Scalia's question yet.
Well, I think in this case there is an easy answer, and that is Justice Kagan pointed out that the Act itself creates a sharp dividing line between the minimum coverage provision, the package of reforms, the minimum coverage provision along with the guaranteed issue and community rating. That is one package that Congress deemed essential.
How do you know that? Where is this line? I looked through the whole Act. I didn't read. Well,
it is in Congress.
Where is the sharp line?
It is in Congress's findings that the minimum coverage provision, without it, the Congress said in finding I, without that provision, people would wait to get insurance therefore cause all the adverse selection problems that gave rise to.
That makes your case that the one provision should fall if the other does. It doesn't tell us anything about all the other provisions.
Well, I think it does, because Congress said it was essential to those provisions, but it conspicuously did not say that it was essential to other provisions.
May I ask you about the argument that's made in the economist's amicus brief? They say that the insurance reforms impose 10-year costs of roughly $700 billion on the insurance industry, and that these costs are supposed to be offset by about $350 billion in new revenue from the individual mandate and $350 billion from the Medicaid expansion. Now, if the $350 billion, maybe you'll disagree with the numbers, that they're fundamentally wrong, but assuming that they're in the ballpark, if the $350 million from the individual mandate were to be lost, what would happen to the insurance industry, which would now be in the hole for $350 billion over 10 years?
First of all, for the Court to go beyond text and legislative history to try to figure out how the finances of a bill operated, it's like being the Budget Committee. But we think the economists have added up the figures wrong. If there's Medicaid expansion, the insurance companies are involved in that, they're going to be reimbursed.
Well, what if there isn't Medicaid expansion? We've talked about the individual mandate, but does the government have a position on what should happen if the Medicaid expansion is struck down?
We don't think that would have any effect. That could be addressed in the next argument, but we don't think that would have any effect on the rest of the
So
Act.
the government's position is that if Medicaid expansion is struck down, the rest of the Act can operate.
Yes. It's in the past, Congress has expanded Medicaid coverage without there being. It's done it many times without there being a minimum coverage provision.
But I still don't understand where you are with the answer to Justice Alito's question. Assume that there is a substantial probability that the $350 billion plus $350 billion equals 7 is going to be cut in half if the individual mandate is strict. Assume there is a significant possibility of that. Is it within the proper exercise of this Court's function to impose that kind of risk? Can we say that the Congress would have intended that there be that kind of risk?
Well, we don't think it's in the Court's place to look at the budgetary implications, and we also.
But isn't that the point then? Why we should just assume that it is not severable?
No.
If we lack the competence to even assess whether there's a risk, then isn't this an awesome exercise of judicial power?
No, I don't.
To say we're doing something and we're not telling you what the consequences might be.
No, I don't think so, because when you're talking about monetary consequences, you're looking through the Act, you're looking behind the Act. Rather, the Court's function is to look at the text and structure of the Act and what the substantive provisions of the Act themselves mean. And if I could go past
Mr. Kneedler, can you give us a prior case that resembles this one, in which we are asked to strike down what the other side says is the heart of the Act, and yet leave in, as you request, leave in effect the rest of it? Have we ever? Most of our severability cases, involve one little aspect of the Act, and the question is whether the rest. When have we ever really struck down what was the main purpose of the Act and left the rest in effect?